What's going on, everybody? We have a drum beat going on, it sounds like.
I'm so sorry. It's a construction zone here on the old homestead today. We've got all the water off, and I haven't showered in days, and I've still got dirt all over me. And
I didn't realize we had the going to the beat of the drum now. So
yeah, it's redo all the plumbing day.
No worries at all. Well, hey everybody, welcome to another episode of the Justice Revolution. I am your host, James the Patriot. Today is October the 12th in the year of our Lord 2023. Hey, can you believe it's been a year? It's been a year since we've done a broadcast, our very first broadcast. Can you believe that?
Oh, really?
It's been a year. Yeah, because somebody, and I feel so bad. I can't remember. Somebody posted in the Telegram group when we posted, hey, the very first ever, we're finally doing a broadcast. And I was like, wow. And that was October 7th of 2022. So happy birthday to us. Yay.
Yay.
Anyway, I have with me both my beautiful co-hosts, Erica and Justice. Justice will join when she can. She's got some things that she's taking care of, so she's going to be in the background just listening. And obviously, you guys know Erica. Looks like we got some construction going on in her house, which is fantastic. So anyway, we've got a lot to cover today. We've gone over a number of things. The title of the show is Law School Students Endorse Terrorists. And I was trying to be surprised and shocked when I saw this. When I heard this earlier this week, I was listening to another radio program and heard that there was a group of students from Harvard University Law School. I want to make sure I get this right. So the name of the group is Harvard Palestine Solidarity Groups. Okay. And they issued a statement on a formal letter. And I'm still trying to find this letter. I can't seem to find it. All I can find is the news stories on it. So I'm just going to read from this news story. This is from the New York Times. It said, immediately after the Hamas attacks in Israel, in which assailants killed women and children, Harvard was quiet even as criticism mounted over an open letter from a student coalition. The letter from Harvard Palestine Solidarity Groups said it held the Israeli regime entirely responsible for all of the unfolding violence. The backlash to that letter turned Harvard's silence into a roar. On Monday, Lawrence H. Summers, the former Treasury Secretary and former Harvard president, condemned the university's leadership for not denouncing the pro-Palestinian letter. In nearly 50 years of Harvard affiliation, I have never been as disillusioned and alienated as I am today, he wrote on X, formerly Twitter. Harvard's silence, coupled with the student coalition letter, he said, has allowed Harvard to appear at best neutral towards acts of terror against the Jewish state of Israel. There's more to it, but I don't really want to go into all those details there. But this is why I wanted to bring this up. These are the people that are supposed to be future attorneys. Do you really want these people representing you in a legal matter?
No.
Erica, what do you think? What are your thoughts to that?
No way. The last several years has changed my perspective on pretty much everything. I don't want a lawyer. I don't want a doctor. I don't want a CPA. I don't want
you don't need any of them.
No.
You don't need any of them. You know, it's our last episode where we had Brent Johnson on. That did stir up quite a bit of, I'm not going to say controversy, but it got some conversations going. Would you agree, Erica? You got some conversations going?
Yeah.
So I wanted to have Brent on, and I need to be very clear with this. It's okay to have people that you disagree with. Not on everything, but maybe you agree on the majority of things, but you disagree on a couple of things. It is okay to have an open conversation. It's okay to bring them on. I brought on Brent for that reason. I've brought on Kirk Pendergrass in the past. Kirk has a very unique view of the law. Some people would say that he's extreme. Some people would say that he's right where he needs to be. I want everyone listening or watching to this show to be able to hear the differences of opinions for how each of them have achieved their own American dream. Brent has been living free from government intrusion for 30-something plus years, and he's been teaching others to do it. Now, his methods are unique. Do your own research. Erica did, and it makes sense. So I'm taking a very calculated approach, probably is the best word to use there, mainly because I'm picking my battles instead of just going, for lack of a better term, balls to the wall and going out there and just saying, I'm no longer putting a license plate on my car. I'm taking my driver's license and tearing it up and do it. Instead of just going crazy like that, I'm taking it one step at a time. I'm picking the biggest battle for me, which is my property tax. And I'm going to talk about that here coming up. That's me. So what I'm getting at with this is, please don't feel that if we bring a guest onto the show that says something that's a little controversial or contradicts something that we've said in the past or that I have said, it doesn't mean that we have completely done a 180. Okay. It just means I want you guys to be able to get a different perspective, a different view. At the end of the day, we all are Americans and we all want to live our lives in peace. That's just it. We just want, I'm sick and tired of the government tyranny. I mean, you guys, the colonialists, they threw tea into the harbor over a 0.5% tax, a 0.5% tax, and they threw tea into the Boston Harbor. So that tells you where they were and where we are now. So, so with that, I want to go back to this whole law schools endorsing terrorist thing. I'm not going to get into this whole Israeli-Palestinian situation, okay? You need to do your own research. That's all I'm going to say. You can't lump a group of people or a religious group of people into one box and say they're all evil or they're all good. You just can't do it. Look at history, you guys. What happened during the Crusades? Erica, do you know what happened during the Crusades?
I know lots of people died.
Lots of people were killed. People were killed in the name of God. The Christians believed that God had told them to go kill all of the unbelievers in the Holy Land. That was the Crusades. That was a religious group that did that. Look at where we are today. There are constant fights and bickerings between other religious groups and affiliations. So just because you see one thing in the news that says, oh my gosh, this terrorist group known as Hamas has gone in and just completely slaughtered people. They have. There's no question about that. They absolutely have. But it's not because, and let me back this up here too. Those people, the leader of that group, the leader of that area, they have all said that they will not rest until the Jews are exterminated. That's what they've said. Okay. Flip side, go over to the other side of the equation there. Go to the Israeli side. There are people and organizations within the Israelis themselves, within the Jewish community, who are not living the Jewish faith the way that we know it, the way that the Old Testament and the Bible preaches it. Okay. There was a comment that was dropped here, and I apologize. I don't know who this individual is. Their screen name is CPalm11. Wanted to know if we're going to talk about the Israeli crimes against Palestinian women and children. I wish I could speak to it. I don't know about it, but I'm not saying it doesn't happen. Okay. Don't confuse me. There's crimes on both sides. There's fighting on both sides. And where I sit, it's a major concern because of where this particular situation is taking place in the world.
Can I chime in at some point, James?
I would love for you to chime in at some point, Justice.
Thanks.
Please do.
Sorry if my birds are...
No, you're fine.
So one of the things is that, to CPOM's comment and to everybody else's comment, what people are losing sight of is that there are puppet masters at the top of all of this.
Yeah.
The globalists know what they're doing to one another, and they're sacrificing their own people. And what they want us to do is get into conversations about Israeli crimes against Palestinians and Palestinian crimes against Israelis and Ukrainian crimes against Russians and black crimes against white and white crimes against black. That's what they're wanting. That's why our four founders said, united we stand, divided we fall, because as long as they keep us divided, the oligarchs maintain control. In my opinion, that's what it's all about. They're being exposed. Ukrainian war is faltering, so they had to create another false flag to get our distraction away from the crimes that they've been committing and that have been coming into the light in the news and in the media and in the Congress and everything else.
I would agree. I'd agree with that 100%. Because what do wars do besides kill an insane amount of people? What do? They fund. Go ahead.
They fund Lockheed Martin and lots of other major war.
They make these corporations an insane amount of money, who then in turn give some of that money to who? The alleged leaders of these nations.
And our politicians.
Exactly. It's the military industrial complex. It's what it is. That is why there has been a major conflict somewhere on this continent for the last 150 years. Somewhere. Because people realized, hey, we can make a lot of freaking money if there's a war. We can make a lot. Do you guys know what pulled the United States out of the Great Depression? Do you guys know, Erica?
World War II.
World War II. Why did World War II pull us out of the Great Depression? You would think it would throw us into depression with the amount of people that were killed during that war.
Manufacturing crime, war material. I'm sorry.
There it is.
Crime material.
Rosie the
Riveter.
There
it is. There. So my great-grandpa was a captain of a submarine. He was a naval commander, naval captain, commander to submarine. He was stationed in Pearl Harbor. He was there up until about a month or two before December 7th, 1941. There was plenty of intelligence. They knew that the Japanese were going to attack. They knew. They just didn't know when, but they knew. The brass, or the powers to be, also knew, but they didn't shore up the defenses. They didn't prepare because they knew the only way that they could pull the nation out of the Great Depression was to throw the United States into the war. When the war broke out in Europe in 1939, the majority of Americans wanted nothing to do with it. Same thing when Japan invaded China. And when Japan started invading all the surrounding islands in 1938 and 37 and 39, the United States wanted nothing to do with it. It's like, we want to stay out of this. But the only way that you could convince the nation to pull us out of the Depression and get us into the war was if they allowed a massive attack. I mean, again, and it worked.
9/11. Yeah.
I was going to say, look what happened after 9/11.
Mm-hmm.
Look what happened. All I'm going to tell you here is, again, going completely off topic from the show today. All I'm going to say is buildings don't fall down like that from an airplane. All I'm going to say. You do not have a controlled fall.
Well, and then also look at Common Law's comment there about the Lahaina cost.
Yep.
It was getting too much attention. See, that's just exactly how I'm viewing all of this. We don't know how much of the atrocities that we see on television are true. They could be using old footage. They could be staging it. I've seen videos where they're staging these scenes and then recording them for the B-roll on the news. And, they try to get us emotionally connected. That's why I just play in the dirt and make medicine and trounce around, and keep all the screens off. This is the only interface that I get with the news. And I'm like, that's what I was just saying. Wait, what happened? Israel? Wait, what happened to Ukraine? That's not a thing anymore?
I know. It's
just
like
a couple days ago. It just seemed like it was just a couple days. And then Lahaina, I don't know. That seemed like.
Yeah, Lahaina, again, just all I'm going to say is just do your own research. Come to your own conclusions. Don't take what I say as gospel truth. Don't take what Erica or what Justice says as gospel truth. I mean, we're just people, and we're just analyzing the information as we have it. Just as I'm sitting here doing this broadcast, I just see it come across my feed that George Mason University, a group there, has put out a statement calling the Hamas terrorist group, which, by the way, there's no what's the word I'm looking for here? I can't think of the words, it's just not coming to my head. There's no question that the Hamas group is a terrorist group, and they're embedded behind Palestinians. They are using innocent men and women and children of the Palestinians as human shields. That's a terrorist group. However, a group at George Mason University, by the way, that's in Washington, D.C., in case anybody's wondering, they just put out a statement where they are calling these Hamas terrorist resistance fighters who are just decolonizing and reclaiming the land that was taken from them. That's not true. Hamas has stated that they want every single Jew killed, dead, gone, wiped from the face of the earth. Okay?
And,
if somebody says...
And there's numerous groups that say that, and they have been saying it
exactly
for years.
Exactly.
And more people are paying attention to politics and news since COVID because it woke a lot of people up. And Americans their way of life got shaken. The Zionists forever believe anybody but a Jew is going to perish from the face of the earth.
And I agree with that. I agree with that wholeheartedly.
We have covertly in America the CIA. They're all terrorist groups. Some are just in your face and not lying about it, and others go behind your back. So
yeah, some are state sponsored, right? Like the 3-letter agency that Justice just mentioned.
Yeah,
some are state sponsored.
Right.
I mean, they've got their sticky hands and fingers in so many different things. So
right. But we, the people, have to love one another and not get wrapped up in this. I mean, my sister-in-law, my brother, I'm Christian. My brother married a Jewish woman. She wants nothing to do with terrorism. She doesn't believe anybody besides Jewish people should die, right? So there's sects inside every religion and every race that are supremacists. All of them have them.
Yeah.
And we're just paying more attention, I think, as an American population. So
yeah, because we were played for fools for the last couple of years.
Yes.
We were played for fools. So now we're waking up. More and more people are waking up. Again, I've said from the very beginning, you know, as we celebrate 1-year anniversary of this podcast, of this show, my purpose for doing this show was to educate my brothers and sisters. I don't care. This is on the record. I don't care what color skin you have. I don't care what country you come from. I don't care what gender you are or what gender you claim to be. I don't care if you think you're a dog. I don't care. I still will love you as my brother or my sister. Or my dog, if that's what you want to be. Okay? I don't care. I don't care. I do this because your right to be able to choose what you want to do with your life, how you want to live your life, and what you want to do in life, that is your right. And I will fight and I will die to protect that right. So the only way that we can preserve that is if we teach each other how to stand on these principles. So this is why I said, I'm not going to get involved in these global affairs. I'm going to leave the geopolitics to the people who were put into office for that reason. And I say put for a very reason, and I'm just going to leave that alone. Okay? I'm going to leave that to those people. I'm going to fight the battles here at home because I've got tyrants who think that because where I choose to buy a house determines whether or not they can tax me. Okay, we're going to go over that today. So with that, I'm just going to leave the whole law school students. Just again, if you guys didn't know if the Bar Association was an evil organization, look no further than what they're teaching these students in law school. Harvard Law School was supposed to be one of the top law schools in the country.
Oh, I think James got frozen. James?
Can you hear me?
Oh, there you are. There you are.
I don't know what happened.
You got frozen for a second.
Yeah, my internet just went out. It was, and now it's back. That is odd. So
it's the Bar Association.
You're right. They heard me say it. So anyway, so enough of that. Let's move on to the good stuff. You guys want to get into the good stuff? Let's get into the good stuff. Let me see here. Okay, so you guys have all been asking for updates on cases. All right, so in my case, like I said, I choose to pick the battles here at home. I want this government off my back. I want them to stop taking my money. So I just I was talking with Justice before the show. I just recently changed positions. I got a new job, better job I'm excited for. And I am excited to report that when they sent me all the information, for getting my paychecks, they sent me a W-4. And I sent to them that form that I sent you, Erica.
Yeah, the W-4.
And I was fully expecting them to come back. We can't use this. You have to do this. You have to do that. No, I didn't hear a thing. So I was like, this is interesting. I just got notification. Payday's tomorrow. So my bank lets me know that there's money that'll be available tomorrow. And I look at it, and sure enough, they didn't withhold anything from my paycheck.
Nice.
So I am getting the full amount that I should be getting. So
of the harvest of your labor, which should be yours entirely. It's your private property.
Exactly. So I no longer have to have these ridiculous fights with the other 3-letter agency that thinks they can take money from everyday good men and women. Okay. Yay. Going forward. That doesn't change the fact that they still have close to $100,000 of my hard-earned money that they're refusing to give back to me.
So James,
yes.
Do you anticipate the IRS then coming after you for this company now and having to have the same fight with them again?
Well, here's the thing. So the company is going to do one of two things. They're either going to not report my earnings at all, which I'm hoping to do, or they're going to submit what's called a 1099, independent contractor. Even though I'm not technically an independent contractor. If they submit a 1099 independent contractor, well, that's simple. I just file a corrected 1099 and call it a day. Because again, that's not evidence that I'm a taxpayer. Again, a taxpayer, you must be exercising some type of a privilege. So there's no
in a
privilege
trade or
there.
a business, which is defined very specifically as a public office.
Right.
Yeah.
But you know how the IRS is. They're relentless. So my thought is now you change jobs, they're going to try again. They're going to make you go through all that again.
And they might, and that's fine. I'll fight the administrative battle. And if I have to take them to court, I will. They've already shot themselves in the foot. I have documentation sitting right here on my desk that says, you don't owe us anything and we don't owe you anything. It's like, well, you got one of those things right. I don't owe you anything.
But that was for your last job is my thought.
Yes. Correct.
Right.
So again, moving forward, since I didn't fill out a W-4, they technically can't file a W-2 for me.
Right.
If they do send something to the IRS, then I just have to go back and say, hey, I just need you to report that as zeros, correct it with them. Or I just submit what's called a corrected 1099. Have you guys ever looked at that form, the 1099? Mm-hmm. There's a box at the top that says corrected. There's no signature on there. There's no signature from the company. You just fill out the information, hit corrected, send it in, and away you go. So I actually helped Sean from the SGT report. He was wondering what he should do with that stuff. I was like, well, just send it a corrected 1099.
The biggest barrier is just everyone who thinks that they're going to get in trouble if they do it. That's where the challenge is. It's not with actually following through and just doing what the law says. It's getting people convinced that they're going to be allowed to and not end up in jail because they've done such a good job, like scaring everyone.
They've done a great job. I mean, because what do they do when they convict somebody for tax evasion? What do? They put that up on news. They plaster it all over the place. So-and-so just got sentenced to 3 or 5 years in federal prison for tax evasion. You see it all the time. But again, if we stand on our principles and if we stand on the right things, they don't have a leg to stand on it. And I'm going to talk about this today. Actually, you know what? Let's see. Let's go there now. I'm going to talk about this now. In our last episode, so not last week, because I wasn't here last week, it was the week before, I was telling you the story about a friend of mine who was building an addition to his house, and he received notification from the municipality that he had to get a building permit and he had to do all these other things. You remember this, Erica? I was talking about this.
Oh yeah.
And I was reading through the letters he sent back and forth, and then Brent jumped on. So I'm going to show he was, ironically enough, the morons that call themselves the attorneys in the case. They went ahead and filed a civil lawsuit, and he was served with this civil lawsuit actually just right after we did that show. So he was served on the Sunday after that show. So he calls me up, or he sends it over to me, and he says, James, what am I supposed to do here? They're actually suing me now. I was like, okay, why don't you go ahead and send me the complaint? Let's take a look at it. So I looked at the complaint, and I actually think I still have it on my desk, but I'm not going to open it up. I looked at the complaint, and I looked at what their causes of action were. And the city, or the township in this case, it's Magna Metro Township. I've got no problem sharing that. This is all public information. So Magna Metro Township was suing this guy for violations of the Municipal Land Use and Management Act, okay, or Development Management Act. It's for short, it's called LUDMA. They were also suing him for building code violations and for violations of a number of city ordinances. Those were their causes of action. You're on mute, Erica.
So much banging going on. That's not,
I know.
Ordinances aren't law though, right?
Correct.
Okay.
But here's the thing. This is why we have to read the laws or the statutes that they're moving under. And I've got some good cases in here that's going to talk about this. Anyway, so I went through and I read this. They had 10 or 15 pages of exhibits attached to the lawsuit. But guess what was not attached to the lawsuit? Erica, you want to take a guess?
I don't know, his permits or
no
evidence that he's.
It was an unsworn complaint. So what?
Oh, an affidavit. There was no affidavit.
It's an unsworn complaint, correct? So there was no affidavit, nothing. So I mean, basically, it's just documents filed with the court. It's the court really doesn't have any teeth to do anything with. So this is how, again, we use the rules to our advantage. Now, I've seen a lot of things, and you guys, again, you just have to know. And I've talked to this gentleman. His name is Bryce, and he's happy that we can share this. I've talked to him and said, hey, listen, don't expect that this is going to work. I fully expect that this judge in this court is going to deny this motion and going to allow this case to proceed. I fully expect that. We don't expect to win our cases in these trial courts because these judges are corrupt. The attorneys are corrupt. They live.
They live, eat, breathe, sleep, total corruption. Right, James?
Exactly. Gosh,
got frozen again, so I thought
my stupid internet, guys. I am so sorry. I apologize. Anyway, these lawyers live in that world, and I don't understand why. So I read through his complaint, and I'm like, oh, this is simple. They don't have subject matter jurisdiction. Right? What's needed to get subject matter jurisdiction, Erica? Do you know?
Well, there needs to be a claim from someone, not Magna Metro Township. That's not.
Yeah,
that's not someone.
Yeah, that's a thing, right? So, who is bringing the claim, not what? So in this case, it's a what.
Claim.
Yeah, it's a what that's bringing the claim. Okay, that's the first part of it. The second part is that all of the elements of the cause of action must be met. So what makes up the elements of the cause of action? We have to go back and you have to read the statute if that's what they're moving under. If they're using a statute, if they're using an act of the legislature, not a common law action and not a constitutional action, but a statutory action, all of those elements must be met. So I went and I read that. So let me go let me just go on down through this because I have it in here. So this isn't a very long motion to dismiss. It's only a few pages. I'm just going to read this. So I said, pursuant to Rule 12b1 and 12b6. Luckily for us here in Utah, our rules they mirror the federal rules. The defendants, as sovereign people of the Union State of Utah, move the court to dismiss Magna Metro Township's complaint against the defendants for the reasons listed below. So why do you think I put sovereign people of the state of Utah? Why would I put that in there?
Well, it establishes that they're one of we the people.
There you go.
And not a part of the municipality employment roster.
Yeah, there's that, and there's other reasons to it as well. So, okay. So here's the relief requested and the grounds therefore. Defendants respectfully move this court for an order dismissing plaintiff's complaint. The grounds for this relief are as follows. Number one, plaintiff has failed to show how it has any property rights or ownership interests in defendant's private property. That's the first. Number two, plaintiff has failed to prove that defendants are subject to the requirements within the legislative intent of the Municipal Land Use Development Management Act, LUDMA, under all these other codes here. I'm not going to read them because they're going to bore you, rendering this court without subject matter jurisdiction to hear this lawsuit. Okay? Remember what I said. In order for the court to have subject matter jurisdiction, all of the elements of the statute or the cause of action that they're moving under must be met. Okay? All right, I'm not going to read through the undisputed facts because it's kind of long, but if Bryce gives me permission, it's not even Friday yet. What's going on?
No, get it together, buddy.
If he gives me permission, I'll post this in the affidavits group. So I'm going to start right here under line number 2. I said the plaintiff appears to assert 4 claims against the defendants. In each claim, plaintiff alleges and relies upon the allegation that defendants are liable to plaintiffs under the Municipal Land Use Development Management Act, as well as multiple municipal codes. Plaintiff's complaint alleges that this court has jurisdiction pursuant to Utah Code Annotated 78A-5-102. When I looked that up, it basically says if the complaint of action occurs in this judicial district, this court has jurisdiction to hear it. Doesn't talk anything about subject matter jurisdiction. Okay? Despite the fact that defendants attempted in good faith to work with the plaintiff never produced their authority to enforce municipal codes and or Utah statutes over defendants and their private property. See the affidavits of the defendants attached to this motion. In fact, plaintiffs never produced any documentation or evidence to defendants or with this action that shows that plaintiffs have any ownership, interest, or property rights in defendants' property and would have standing to enforce their municipal codes and or Utah statutes related to municipalities and building enforcement. Okay? So the argument under, I'm not going to read through this here. This is pretty standard. You know, a motion to dismiss that's brought under Rule 12b6 should be granted where, even accepting the factual allegations as true and drawing all reasonable inferences in the plaintiff's favor, the plaintiff is not entitled to relief. So basically the argument we're stating is we're not saying that anything that's in the complaint isn't true, but it still doesn't entitle them to relief. Okay, and you'll see why that is here. Okay. Additionally, a facial attack brought under a Rule 12b1 motion to dismiss must be granted when the facts and evidence that are incorporated into the complaint show that the district court is without subject matter jurisdiction to hear the case. Okay, so a facial attack, and it's right here again, assumes the allegations in the complaint are true and argues they failed to establish jurisdiction. Okay, so let's get down to the meat and potatoes. Number 1, the plaintiff's allegations of property rights and or ownership interest fail as a matter of law. Plaintiff asserts 4 claims against the defendants. Each claim either specifically refers to or relies on the allegations that plaintiff has some unknown ownership interest and or has property rights delegated to it by the legislature in defendant's private property. Each of the claims allege that defendants violated either Magna Municipal Code or Utah Code or both. Generally, in order to enforce Municipal Code and or Utah Code within the meaning of the moving action, which is called LUDMA, a municipality must show through the pleadings that it has either ownership interest in or rights within the property it seeks to enforce its code upon, or there is a causal nexus between the municipality and the entity. The Utah Supreme Court held that jurisdictional thresholds, such as those propounded by Article, oh, my Roman numerals are bad, XIII, I think that's 13. Yeah. By Article 13, Section 10, assure that taxes are not levied arbitrarily against persons or property having no substantial contact with the levying entity. Where there is no genuine contact, a levying entity cannot justify funding its institutions or operations by collecting from a stranger. Okay, that's from the Utah State, that's the Utah Supreme Court. They go on to say, hence, under Article 13, Section 10, the levying entity must demonstrate a substantial or tangible nexus of some kind between the ownership or use of property and the territory of the entity itself. Okay. You're going to see when I pull up the reply that the defendants in my case submitted to my response, you're going to see how they think that because where your property sits, as long as it's within the geographical boundaries of either the county or the municipality, that gives them the right to tell you what you can and cannot do with your property. Hey, Erica, if I can't make you do something, can you make me do something?
No.
So what if I was to say, well, I'm the city manager and I'm from big, bad, powerful, the city. Can I still make you do something if I can't turn around and tell the city what to do?
Only if you use force and it's under duress, coercion, threat, intimidation.
The short answer is no.
Short answer is no, though. Yeah.
The short answer is no. Okay. That's exactly what the Utah State Supreme Court is saying here, is that the levying entity, so the entity seeking to get a fee or a tax, must demonstrate a tangible nexus. Tangible. What does tangible mean? Something you can touch and feel. That's what tangible is. A nexus is a connection between the two of you. So that means there must be some type of a connection between the two of you. Well, what connection is it? They would argue, well, that connection is because where your property is located. Oh, really? Did you guys create the land that my property sits on? Did you guys do that? Are you guys now God? Is that what you're telling me? Because that's nonsense. But this is the stupidity of these liars that argue this crap. Okay, let me move on. I said plaintiff has failed to show within their pleadings the substantial contact that is required in order for them to bring these claims and adjudicate them in this court. Additionally, they have not shown they have the authority to dictate to the defendants how the defendants can exercise their property rights. Then I slap them across the face with this one. In the Utah Supreme Court case, Metro Water District of Salt Lake City and Sandy versus SHCH Alaska, the Metro Water District attempted to use Utah Code 17B and some other numbers, I won't bore you, as its basis to force upon and extinguish private property rights in its operation of its business purposes. Ultimately, the justices rejected this assertion. They stated that the statute would not authorize Metro to lease, sell, or license property interests it does not own, nor dictate how a private property owner may use his or her property rights. This interpretation, unlike Metro's proposed interpretation, is consistent with traditional property principles regarding the nature of the respective parties' existing property rights. Okay? Plaintiff does not claim, nor did they provide any evidence to this court, any nexus.
I have a question, James.
Yes, go ahead. Go ahead.
What was the basis of the water company wanting to sell that property? If the justice said,
That case actually surrounded an easement. It was like a water pipe or something like that.
Uh-huh.
And so they tried to tell the property owners where they were going to put their pipe on their property that was outside the easement zone. And the people who own the property told them to go pound sand, and so that they sued them. And then the court said, no, you don't have a right to tell them what they can do with their property, basically.
So that can go for anything. That can go for people in foreclosure. That can go for that case.
Well, sort of. See, foreclosure is a different story because, again, in a foreclosure case, when you sign that deed of trust, you're granting the bank the authority to force you to sell your property. But see, what people don't realize is if they're foreclosed on, they think they lose the entire value of the property. So, for example, I'm getting off on the weeds here, but for example, let's say that they owed $150,000, but their property was worth $1 million, and the bank forces them to sell, and they get $900,000 for the property. What's been happening is the bank has been keeping all $900,000
instead of the 150.
That's
right.
Exactly. That's against the law.
What I'm saying is, in what was stated in there in that case was that without representation of ownership.
Exactly.
And the banks are on because they sell, and I mean, let's look at our case, right?
Mm-hmm.
There's been no verification of ownership.
Yeah. See, so again, it all comes down to being able to enforce the rights of whatever it is their moving cause of action. Like if it's the contract, if it's the deed of trust, if it's any of these things. Yes.
Right, without proof of interest in the property.
Exactly.
Right. Okay.
Exactly.
It just struck me as the same thing as that we went through, and it's like,
yeah.
Okay.
So here's where I finished this one up. I said the plaintiff does not claim, nor did they provide any evidence to this court, any nexus or causal connection between them and the defendants. Again, I'm going back to there's no contract in place. There's no, we're not a taxpayer type of a thing. I said the only way the sovereign defendants would be required to obey any orders or ordinances would be if they are a legal entity, as defined within the statute, within the legislative intent of the statute. This principle is affirmed in this ruling from the United States Supreme Court that stated, we the people form the governments of the several states. Under our constitutional system, therefore, a state is not the sovereign of its people, rather, its people are sovereign. Because the people of the state are the ultimate sovereigns and did not delegate the authority to the legislature to dictate what can and cannot be done with our private property so long as it does not infringe on anyone else's rights, plaintiffs' claims for relief fail as a matter of law. Accordingly, plaintiffs' claims against the defendants must be dismissed.
Oh my gosh, that's beautiful. That's my favorite sentence. That's good.
You think that's good? Wait.
It gets better? Okay.
It gets better. Okay. Number 2, plaintiff's complaint fails for lack of subject matter jurisdiction. All right. I found these 2 cases here. These are Utah cases, and they're really good. It says the party invoking jurisdiction bears the burden of establishing these elements, i.e., the elements of standing. Since they are not mere pleading requirements, but rather an indispensable part of the plaintiff's case, each element must be supported in the same way as any other matter on which the plaintiff bears the burden of proof. For example, with the manner of degree of evidence required at the successive stages of the litigation. That's the most important part. Manner and degree of evidence. To have standing to assert a claim, a plaintiff must clear 2 hurdles. The first hurdle emanates from the law that establishes the plaintiff's right of action, the common law, a statute, or the Constitution. If the plaintiff is asserting a statutory claim, for example, he has standing only if he is within the class of parties that the legislature authorized to file suit. This is sometimes called statutory standing. The second hurdle is constitutional. Even if the plaintiff has a statutory right to sue, he may lack standing if he does not meet the constitutional requirements for standing. Under our cases, the traditional standing test requires proof that the plaintiff suffered a distinct and palpable injury that gives rise to a personal stake in the outcome of the dispute. That's from the Utah Supreme Court. So I said, under these thresholds established by the Supreme Court of Utah, the plaintiff has failed to show with evidentiary support that this court is vested with the subject matter it needs to hear and litigate this case. Even if the court could proceed, doing so would greatly prejudice the defendants and would extinguish their sacred property rights that existed long before plaintiff's creation as a municipality and long before we, the people, ordained and established the Union State of Utah with the Utah Constitution. The main cause of action used by the plaintiff is the Municipal Land Use and Development Management Act, codified in Utah Code Annotated 10-9A-101. Within the definition sections of this act, it states that the definition of a person as used within the act means an individual, corporation, partnership, organization, association, trust, governmental agency, or any other legal entity. It is clear from this wording that the legislative intent with this statute was to apply only to legal entities organized and incorporated under the laws of the state. To say otherwise is an egregious abuse of power by the plaintiff in this case. The plaintiff is attempting. Did you have something you want to say, Erica?
I just love it. I loved that too. I just wanted to tell you that, but I forgot I was muted because there's so much banging going on. Okay, go ahead.
Yeah, you're good. I said the plaintiff is attempting to exercise powers that it expressly does not have, as these powers cannot be delegated to the plaintiff by the legislature, as the legislature is prohibited from exerting these powers, as well as it is laid out in the Utah Constitution. This is my favorite case of all of them. The fear of local governments abusing their delegated powers as a justification for strict construction of those powers is a slur on the right and the ability of people to govern themselves. Adequate protection against abuse of power or interference with legitimate statewide interests is provided by the electorate, state supervisory control, and judicial review. Strict construction, particularly in the face of a general welfare grant of power to local governments, simply eviscerates the plain language of the statute, nullifies the intent of the legislature, and seriously cripples effective local government. There are ample safeguards against any abuse of power at the local level. Local governments, as subdivisions of the state, exercise those powers granted to them by the state legislature, and the exercise of a delegated power is subject to the limitations imposed by state statutes and state and federal constitutions. A state cannot empower local governments to do that which the state itself does not have authority to do. In addition, local governments are without authority to pass any ordinance prohibited by or in conflict with state statutory law. In short, what the Supreme Court said is if the legislature doesn't have the authority to do it, they don't have the authority to do it. The legislature cannot grant itself rights in people's properties simply because it's within the geographical boundaries of the state. It's not how this works. So, in short, the plaintiff is attempting to confer subject matter jurisdiction to this court where it is clear from the legislative intent that it does not belong. The record clearly shows this, and this court would abuse its discretion and greatly prejudice the sacred property rights of the defendants if this court were to deny this motion. For this reason alone, this court must dismiss this action for lack of subject matter jurisdiction. Okay? And then I made this even more. I love throwing in judicial notices under the rules of evidence. So every state has them. The federal government has them. Here in Utah, it's the rule of evidence, Rule 201, which is where it says the court can take judicial notice of things that are they're just generally known. For example, if this was paramount to my case, I could say, hey, I want the court to take judicial notice of the fact that the sky is blue when it's not raining. Things like that. But in this case, I want the court to take judicial notice of the following undisputed evidentiary facts. Number one, there is no evidence submitted with the plaintiff's complaint of a nexus or causal relationship between the plaintiff and the defendants. Furthermore, there will be none even if discovery is permitted in this case. It doesn't exist. There's no contract submitted with the plaintiff's complaint between the plaintiff and the defendants. There's no business license or articles of incorporation indicating a legal entity submitted with the plaintiff's complaint that proves that defendants are legal entities within the meaning of the plaintiff's cause of action. There is no tax return filed with the plaintiff by the defendants submitted with plaintiff's complaint that would prove a nexus or causal relationship between the plaintiff and the defendants. Okay? In short, my conclusion says this case has to be dismissed. The complaint fails to allege any facts that would grant them relief that this court could grant, fails to meet the requirements of their main cause of action, thus depriving the court of subject matter jurisdiction, and otherwise fails to meet any pleading standard on which this court can grant relief. Okay? What do you guys think? Questions?
I think that sounds great.
Eleanor,
I just love what Eleanor said. I know. I'm glad you pulled.
You are too kind, Eleanor.
You're learning the real law from you, James.
Oh gosh, and it's really sad. It really is sad that when you go into these courts that are supposed to be courts of law, and that these guys who wear black robes and these morons who put on suits and ties, they're supposed to know this stuff, and it's mind-boggling how they don't know. And I'm going to show you. I'm going to show you right now how they don't know. Let me open up. I posted this in the affidavits group, so if some of you may have seen this, let's see. I think this is.
I think they don't know by design, James.
Yeah. Oh, nope.
Right. Just like every industry.
Yeah. Yep. That's the one I want. Okay. So here's an update on my case. All right. So if you remember, I filed my property tax lawsuit. They filed a motion to dismiss, and they're asking the court to dismiss it under the same two causes that I just read, under lack of court subject matter jurisdiction and failure to state a claim. Their entire argument rests on the fact that that I'm a taxpayer and that I must seek remedy through state courts because there's a federal law that prohibits federal courts from taking those type of actions or placing an injunction. So that's where we are there. Okay. So if you remember, I filed my reply that said, these guys are morons. They don't get it in short. And their entire argument is they don't, and this is what Alphonse has been saying. They think the attorneys, the county, the people, they think that the income tax and property tax are standalone things. They think they're two separate things. They don't think that they must go together. They don't get that. They think they're separate. And you're going to see that in this reply. So under the argument, so their reply under the 12B1, this is defendants in their motion have explained why the Tax Injunction Act divests the court of subject matter jurisdiction in this case. That's what I'm talking about. In doing so, they have relied on legal arguments supported by statutes and case law and not on any facts from outside the plaintiff's complaint. In particularly, they have cited Utah Code annotated, oh, there it is, which states that when a taxing entity demands or enforces a tax, the person whose property is taxed may bring an action in the state district court seeking relief. Again, they say person. These people are thinking that that's the general term. No, it is not. A person is a taxpayer. Look up the definitions.
James, would you explain what annotated is as well, please?
So Utah Code annotated means the legislature issued the law, governor signed it into law, and there's been cases that have been brought before the courts, and the courts have determined what the statute means. That's what annotated means. So if you were to search up an annotated code, so for example, if I was to copy this Utah Code here, and I was to go into Westlaw or some other place, I could see what the judicial decisions were based off of that code. All the cases that were surrounding that code. That's what annotated means. Good question.
Thank
so then
you.
they go on. Contrary to what plaintiff asserts, defendant's subject matter jurisdiction arguments are not based on plaintiff's status as a taxpayer, and defendants do not view plaintiff's claimed status as a taxpayer or not a taxpayer as an issue of material fact. That is everything,
it's everything.
I'm arguing. Does this make sense to anyone?
No, not to me at all. Like, are you kidding?
It's so interesting.
They're saying, no. He keeps bringing that whole thing up. It's not even a part of this. It's everything of this.
It gets better. Plaintiff's own citations to the definition of taxpayer come from Title 59, Chapter 10 of the Utah Code, which is the Individual Income Tax Act. This definition is irrelevant to this case because it only applies to the use of taxpayer in the Individual Income Tax Act, not the Property Tax Act, which is found on, wait a minute, Title 59, Chapter 2. Okay. Defendants assert that the arguments in their motion are correct, and they continue to request the court dismiss the case for lack of subject matter jurisdiction. Again, my head is freaking spinning. They don't get it.
Does it say anything different in Chapter 2 than Chapter 10?
There is no definition under Chapter 2 of what a person is or what a taxpayer is. It's not there. The only place I could find the definition was here under Chapter 10. But there's a reason why they're under the same title, because they all belong together.
Right.
See, these idiots conveniently leave out the fact that I stated multiple times in my complaint and in my reply that in Article 1, Section 1 of the Utah Constitution, that I have a right to acquire, possess, and protect property. It's nowhere in any of this stuff. See, they're arguing statutory crap. Statutory crap. They think that statutes are the God's gift since sliced bread. That's what they think. This is how the Bar Association has converted and convoluted people's minds. Okay?
And they always forget the main thing, that the reason any of our government was created in the first place was to protect individual rights to things like property. Mm-hmm. And now they're using it to, I mean, that's just like the big picture. Sometimes I have to step back and be like, wait a second.
It gets better.
No. I mean, for them, statutes are the greatest thing since sliced bread.
Yep. So here's something interesting. All right. They go on to Rule 12b-6. They said in their motion, they have explained why some of the fundamental laws that apply to the facts alleged in plaintiff's complaint, along with why plaintiff's complaint fails to state a claim upon which relief can be granted. In particular, the motion shows the state's constitution's establishment of a property tax and the primary state code section that implements the constitutional mandate, either of which is limited in any way to property that is used. Neither of which is limited in any way to property that is used for business or commercial purposes. That's wrong. They said the Utah Supreme Court has confirmed that residential property is subject to taxation under the Utah Constitution and Utah statutes. They're not wrong. With a partial residential exemption in the form of a 45% reduction in value. Okay? They're not wrong there either. If you are a taxpayer, you are entitled to a 45% reduction in value. And you're going to look at every single one of these cases, states taxpayer this, taxpayer that, taxpayer this, taxpayer that. They say the exhibits and affidavit that accompany the complaint do not change the legal analysis in any way and were considered part of the complaint for defendant's motion. Nothing else in the response clarifies or adds any substance to the deficient conclusions of the complaint. For example, plaintiff mistakenly characterizes the tax on his property as a commercial tax that is only allowed if there's some nexus between his property and commercial activity. I just read a Utah State Supreme Court that says that there has to be a nexus. So then what is it if it's not a commercial tax? Nowhere in his complaint, including the exhibits and affidavit, is there any evidence that the tax imposed by defendants was commercial in nature. So you're telling me that I can just send someone a tax bill and just call it a tax and that they're obligated to pay me? Is that what you're saying here? Mr. Stupid Liar? Is that what you're saying here? Is that it, Erica? Is that what he's saying here? Is that what you're coming?
Who knows what this guy is saying, really? I mean, what's the alternative? If it's not commercial, it's what? Personal?
It's just a tax. It's just, I mean, again. So are you saying that I can just be taxed because I own property? Is that what you're trying to tell me? Because none of this is holding any water whatsoever. You notice how he conveniently leaves out Article 1, Section 1. and jump straight to Article 9 or 10, which is the revenue section of our Constitution. There's a reason why the Declaration of Rights are first, because everything that's listed there, the legislature is prohibited from touching it. So I want to know how they're going to come over that argument. He says, for example, plaintiff mistakenly characterizes the tax on his, I already talked about that. Moreover, plaintiff's arguments about non-commercial property not being taxable are faulty. His citation to Article 1, Section 8, Clause 1 refers to congressional taxing power, and that's the federal Constitution, refers to congressional taxing power and has nothing to do with the state's authority to assess a property tax. Oh my gosh. Erica, I'm going to freaking lose it.
Don't lose it, James. We need you in this fight.
I'm going to freaking lose it.
Keep it together, man. Just crush them.
In the hell do you
I'm just wondering, how many lawyers did it take to write this crap up? That's what. How many do you think? There's three that converged together their brains to come up with this?
Yep, there's 3 of them. And I bar grieved the crap out of all 3 of these. And I attached all other filings, and I attached my complaint to the bar grievance. Not like it's going to do anything, but they're going to know that I bar grieved them. It says, likewise, in the case Flint versus Stone Tracy Company, I like the guy's name, addressed a corporation tax enacted by Congress and is inapplicable to state property taxes. No legal authority supports plaintiff's implied argument that property tax is improper without a commercial nexus to the state. Really? You're stating that no legal authority. So you seem to say and think you know more than the justices of the Utah State Supreme Court. Is that what I'm hearing you say? Because they just said there has to be a commercial nexus to the state. Finally, his Utah Supreme Court case excerpt fails to support his conclusion because the case merely confirms that for a taxing entity to assess a tax against a property, there has to be a substantial or tangible nexus of some kind between the ownership. He just contradicted himself. Did he not, Erica?
You know, I'm reading that over again because
it doesn't make any sense.
No, it doesn't. It fails to support.
Oh.
He's saying there doesn't have to be a nexus, but then he says there does have to be a tangible nexus of some kind. I don't know.
It doesn't make any sense at all. So, I mean, he says...
But then he's saying that there is a nexus that exists.
Because he says... Yeah, I mean, let me read this again. Finally, his Utah Supreme Court case fails to support his conclusion because the case merely confirms that for a taxing entity to assess a tax against property, there has to be a substantial or tangible nexus of some kind. Plaintiff has acknowledged that the property at issue in this case is in Weber County, so the required nexus exists. Oh, okay, there it is.
There it is, because it's in Weber County.
Yeah, okay. That's... Again, you cannot be taxed for the mere privilege of living. That's what this dipwad is arguing. He's arguing.
And he didn't even talk about the thing that Brent was talking about, which is the voluntary services that you're getting from living in Weber County.
Because he won't. Okay, Brent is a million miles ahead of these people. They don't get that. They don't understand that. They think that they can tax you because the legislature says they can.
Well, they should come up with a different argument because that one, like the whole reason they exist is to protect you, not to tax you.
So again, they say plaintiff's arguments related to defendants presenting matters outside the pleading are unsupported and incorrect. Okay. As explained above, defendants do not rely on a characterization of plaintiff as a taxpayer. Well, then what in the crap am I? And do not view this status or lack thereof as a material fact. So they have not made any such arguments in their motion. Again, you just controverted and contradicted yourself. Okay, I gotta close this. I'm gonna lose it. So practice breathing exercises in and out. Oh my goodness. You guys, this is what happens with these stupid liars. This is what they do. After Etane, how many lawyers does it take to change a light bulb? Oh, you couldn't get enough to change the light bulb because they'd all argue with each other, which is the statutorily correct way to do it. So after these guys filed this reply, I filed a motion for a preliminary hearing. According to Rule 12I, that's something I can do. They filed a reply to my response, and they said that there's nothing that says they have to give a response, and they don't need to do that, and the court does not obligated to give you that. And then they cited a bunch of cases that they say support their position. I went and read those cases. This is why we read these cases these guys put in their stuff, because it's nowhere to be found. That's intentionally material false statements. They're intentionally attempting to mislead the court. So what can we do with that? Well, we let the court know. So that's something I did. I just filed yesterday my reply brief to them. And I said, case precedent, according to the 10th Circuit Court of Appeals, which is the Court of Appeals I'm in, states that I'm entitled to a hearing and that you guys should give me one, that the court should give me one. And also, your continued use of falsely stating what judges are saying in their opinions is done. So I took the two cases that they were relying heavily on. I went and found them. I found the sections where they said that this is what it said, nowhere to be found. I highlighted it and attached them as exhibits to my reply. Now I'm going to let the judge.
Nice.
Wait, what? What they're stating is not in the case?
Correct. Here, let me just...
They're desperate. That's what that means, James.
Yes.
They can't defend themselves, so they're saying total nonsense and making stuff up, and then saying, we're not going to show you anything. We don't need a meeting. We don't need to do that.
Yeah.
Because they don't have anything.
Let me close this one. And all right. So let me share this one real quick, and then we're going to end the show here pretty quick. But this one. All right. So this was my reply brief. And I stated in here that defendant's counsel's intentional use of false statements intended to mislead this court. Within defendant's argument under subparagraph A, counsel states numerous cases that purportedly support counsel's position that this court should not grant a hearing. However, upon review of these non-controlling cases, because they're other district courts, it's not from the appellate court, it is clear that counsel is deliberately attempting to mislead this court to get this case dismissed for their clients sans a hearing. For example, counsel states that Rule 12I is not the appropriate means of making such a request, and that Rule 12I simply requires that, upon the request of a plaintiff, the court must resolve a 12B motion asserting a defense prior to trial. And this is the case that they cited. However, upon review of this case, which reference is attached to this reply brief as Exhibit A, the actual verbiage reads as follows. The plaintiff also moves for a Rule 12 preliminary hearing. Incident to the defendant's motion to dismiss, the plaintiff purports to make this request pursuant to Rule 12D, not 12I, 12D, which he contends states that upon application of any party, there shall be a hearing to address defenses pleaded in a Rule 12 motion to dismiss. Rule 12D says no such thing. It merely requires the court receiving evidentiary material in support of a Rule 12 motion to permit the opposing party the opportunity to submit evidentiary material in response. The court has scrupulously, that's a tough word to say, ensured that in deciding the defendant's Rule 12 motions, it did not look beyond the allegations in the amended complaint. Accordingly, there was no need for leave to submit evidentiary material under Rule 12D, and the court is aware of no authority that entitles a party to a hearing to address defenses raised in a Rule 12 motion. This motion is denied. So then I state, nowhere in this decision is Rule 12I discussed, except in the footnotes section, which is available in the attached Exhibit A. This is a blatant attempt by counsel to influence this court's decision and greatly prejudices the plaintiff. I didn't say. Counsel goes on to state that no hearing is required or needed in order to determine the merits of a motion to dismiss, even though one party cited Rule 12I in its request for a hearing. He then cites this one, this LNV Corp v. Hook. I said this too is untrue and is not what is written in the opinion, which is attached here as Exhibit B.
Nice.
The magistrate judge in that case simply stated that no hearing was required or needed to determine the merits of the defendant's 12b6 motion. I said, plaintiff knows and understands that whether this court grants an oral hearing or does not violate plaintiff's due process rights. However, given the complexity of the issues presented before this honorable court and the controlling opinions of the 10th Circuit Court of Appeals, plaintiff believes that good cause exists and respectfully requests that this court grant his request for an oral hearing. Okay. Yes. C to AZ. I'll post this in the chat group so you guys can have that. So, okay. So that's where we stand. So what I'm going to do as soon as I end the show now is I'm going to write up what's called a plaintiff's request to submit for a decision. And I'm going to tell the court, this is everything that's on file. These are the dates that were filed. I'm asking the court to set a hearing. A hearing was requested. I'm asking the court to set a hearing. And then I'm going to be the squeaky freaking wheel. I'm going to email the judge's chambers every single day until I get an answer that I want.
You're going to pull an Alphonse.
I'm going to pull an Alphonse. Awesome. I'm going to be the mouse that just continually runs in the wheel and makes the squeak, 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 squeak. That's going to be me. And I'm sorry, Judge, if you don't like it, but justice delayed is justice denied. Okay? So, questions from you two, Justice or Erica?
So, if you've got a lawyer who is citing things that are clearly wrong, is that not a crime?
Yeah. Say what? Ask the question. What's the recourse when they lie?
Yeah.
Yeah. So, again, they're not lying under oath, so it's not technically perjury. They're intentionally trying to mislead the court, so that can be interpreted as fraud upon the court. It's a sanctionable offense. So my job is to call that to the judge's attention. Hey, judge, this guy's he's not quoted, because again, if you're going to cite from a case, you've got to copy it word for word. Right. Copy and paste. No, it's these guys write up what they wanted to say, and then they put the case in there, and just they think that I'm going to be like every other attorney who doesn't bother checking the cases, because that's not how it works. So,
I'm not feeling well today, so I was not in the mood to be on screen. That's why I'm invisible. Yeah. Sorry.
Yeah. Jar, the proprietor, says, "Why is Justice invisible?"
Sometimes and I haven't showered in 3 days, but I just put a hat on. So yeah,
I was gonna say, Erica, I could smell you from here. No, I'm just teasing.
Wow.
So that's what, again, it's Dr. Graves is not wrong. The rules rule. And at some point, we're going to get an adult in the room. At some point. I'm not expecting to get that adult at the trial court level. I'm not. That's why. So you got to make the record. And this is what we do. We're making the record stating, hey, these guys are openly misleading this court.
Right.
They are trying to get their clients off the hook. And I've done everything to work with these people. I sent them another email and said, hey, this is your last chance. I'm willing to settle with you, and here's how much I'll settle with you on. They rejected it. Okay. So when the court denies this, because I'm really tying the judge's hands, if he grants their motion, I'm going to submit a motion to reconsider, and I'm going to point out all the inaccuracies. I'm going to give the judge another chance and say, hey, judge, you can't. There's the grounds that they're seeking that this be based on do not apply, and here's why, which I've already done.
I was going to say, well, why don't you save yourself time and just do it now?
Well, because I can't, because the judge hasn't done anything yet. But when he does, okay, I'm going to point out his failures, and then I'm going to appeal this to the 10th Circuit Court of Appeals and say they should not have dismissed my case. I do not have any adequate remedy at law. And I even put into the case, there's a beautiful case from the 10th Circuit Court of Appeals that states that non-taxpayers do not have an adequate remedy at law to recover funds taken from them under the color of authority. Our only adequate remedy at law is to sue these people for constitutional violations, which is what I've done. So anyway, with that, I'm going to end the show for today. Hey, look at that. 1 hour and 16 minutes. I'm impressed.
That's good.
God, last time we were 2.5, almost 3 hours. I mean,
that was
crazy.
a bobble. It was okay.
Yeah, it was. Yeah, because we had a little bit of a time issue
delay.
There,
Yeah.
But I'm sure we'll get that figured out. So
I did separate that show, by the way.
Oh, cool. Thank you.
So it's
that was good, Justice. Way to go.
Yeah, we just got the Brent part and our commentaries left to memory.
Okay, good. So with that, I am not sure if I'm going to have a show coming up this week. I will let you guys know. I'm heading out of town tomorrow for work, and I get back on Tuesday. Starting a new job is kind of hectic, so I've been going through some things. But if we do, we'll put it up in the group, and you guys can join. Thank you so much for everybody being. Again, it's not even Friday, Erica. What is going on?
You know what? You just be you, James. You just be you, and we.
I didn't even show you my shirt today. It's just here. Let me see.
Just a regular dad. Oh, now you disappeared.
Yeah, it's the just a regular dad trying not to raise liberals.
Oh,
I thought that show would be I thought that shirt would be appropriate. My wife bought this for me, so
that's anyway. Good.
Very cute.
Thank you so much, everybody, for joining. God bless you all. We will see you on the flip side. Take care, everyone.
Okay, bye.